Dear friends, good morning. Today I will discuss with you section 389 of the CRPC, which is known as the law on the suspension of sentence. We are all aware nowadays if any member of assembly or member of parliament is convicted for 2 years or more, then he loses his membership immediately from that house. That's why the politicians are now coming to the courts for suspension of sentence under section 389. Before going into this subject, I will tell you that I am taking contents from so many judgments which are giving light on this section, and the latest judgment of the Supreme Court of India under Criminal Appellate Jurisdiction, Criminal Appeal Number 311, 1331 and 1332 of 2023 has also been taken into my mind to proceed further on the topic. Now coming to first judgment which I am going to discuss is Kashmira Singh versus State of Punjab 1977. In this judgment, in para 2 of the judgment, it is observed that it would indeed be a travesty of justice to keep a person in jail for a period of 5 or 6 years for an offence which is ultimately found not to have been committed by him. Can the court ever compensate him for his incarnation which is found to be unjustified? Would it be just at all for the court to tell a person, we have admitted your appeal because we think you have a prima facie case, but unfortunately we have no time to hear your appeal for quite a few years, and therefore until we hear your appeal you must remain in jail, even though you may be innocent. When confidence would What confidence would such administration of justice inspire in the mind of public? It may quite conceivably happen, and it has in fact happened in a few cases in this court, that a person may serve out his full term of imprisonment before his appeal is taken up for hearing. The question is, would a judge not be overwhelmed with a feeling of contrition while acquitting such a person after hearing the appeal? Would it not be an affront to his sense of justice? Of what avail would the acquittal be to such a person who has already served out his term of imprisonment, or at any rate a major part of it? It is therefore absolutely essential that the practice which this court has been following in the past must be reconsidered, and so long as this court is not in a position to hear the appeal of an accused within a reasonable period of time, the court should ordinarily, unless there are cogent grounds for acting otherwise, release the accused on bail in cases where special leave has been granted to the accused to appeal against his conviction and sentence. The mere fact that during the period of trial the accused was on bail and there was no misuse of liberty does not per se warrant suspension of execution of sentence and grant of bail. What is really necessary is to consider whether reasons exist to suspend execution of the sentence and grant of bail. Now coming to Bail Act, that is section 389 of CRPC, which reads, subhead is 389 suspension of sentence pending the appeal, release of appellant on bail. Subsection 1 of 389 says, pending any appeal by a convicted person, the appellate court may, for reasons to be recorded by it in writing, order that the execution of sentence or order appealed against be suspended, and also, if he is in confinement, that he be released on bail or on his own bond, provided that the appellate court shall, before releasing on bail or on his own bond a convicted person who is convicted of an offence punishable with death or imprisonment for life or imprisonment for a term of not less than 10 years, shall give opportunity to the public prosecutor for showing cause in writing against such release, provided further that in cases where a convicted person is released on bail, it should be open to the public prosecutor to file an application for the cancellation of the bail. The second subsection says the power conferred by this section on an appellate court may be exercised also by the High Court in the case of an appeal by a convicted person to a court subordinate thereto. Subsection 3 says, where a convicted person certifies the court by which he is convicted that he intends to present an appeal, the court shall, where such person being on bail is sentenced to imprisonment for a term not exceeding 3 years, or where the offence of which such person has been convicted is a bailable one and he is on bail, order that the convicted person be released on bail unless there are special reasons for refusing bail for such period as will afford sufficient time to present the appeal and obtain the orders of appellate court under subsection 1. And the sentence of imprisonment shall, so long as he is so laid on bail, be deemed to be suspended. Now, subsection 4 says, when the appellant is ultimately sentenced to imprisonment for a term or to imprisonment for life, the time during which he is so laid shall be excluded in computing the term for which he is so sentenced. So, what this word suspension conveys? Suspension conveys postponement or temporarily preventing a state of affairs from continuing. If we go by the 7th edition of Black's Law Dictionary, the word suspend means inter alia, to interrupt, to postpone, or to defer. Black Law Dictionary describes the word suspension to mean an act of temporarily delaying, interrupting, or terminating something. If we go by the edition of 1998 of New Oxford Dictionary of England, it describes suspend as temporarily preventing from continuing or being enforced or given effect, or to defer or delay an action, event, or judgment. Thus, when we speak of suspension of sentence after conviction, the idea is to defer or postpone the execution of the sentence. The purpose of postponement of sentence cannot be achieved by detaining the convict in jail. Hence, as a natural consequence of postponement of execution, the convict may be enlarged on bail till further orders. The principle underlying the theory of criminal jurisprudence in our country is that an accused is presumed to be innocent till he is held guilty by a court of competent jurisdiction. Once the accused is held guilty, the presumption of innocence gets erased. In the same manner, if the accused is acquitted, then the presumption of innocence gets further fortified. So, from perusal of section 389 of the CRPC, it is evident that save and accept the matter falling under the category of subsection 3, neither any specific principle of law is laid down nor any criteria has been fixed for consideration of the prayer of the convict. And further, having a judgment of conviction, raising the presumption leaning in favor of the accused regarding innocence, till contrary recorded by the court of competent jurisdiction, and in the aforesaid background, there happens to be a fine distinction between the prayer for bail at the pre-conviction as well as the post-conviction stage. That is section 437, 438, 439 and 489 subclass 1 of the CRPC. Now coming to another judgment, that is Bhagirath versus State of Gujarat, that is of 1984. And there are two other judgments also, Shaheen Welfare Association versus of Union of India of 1996, Joginder Kumar versus State of UP of 1994. In this judgment, the Honorable Supreme Court held that, in our opinion, none of the aforesaid decisions can be said to have laid down any absolute and unconditional rule about when bail should be granted by the court and when it should not. It all depends on the facts and circumstances of each case, and it cannot be said there is any absolute rule that because a long period of imprisonment has expired, bail must necessarily be granted. So, longer period of being in imprisonment is not a solid cause to grant necessary relief. Another judgment of the Honorable Supreme Court, that is Ash Muhammad versus Shivraj Singh or Lala Babu and another. The question should be posed whether the accused deserves to be enlarged on bail or not, and only thereafter issue of imposing conditions would arise. We do not deny for a moment that period of custody is a relevant factor, but simultaneously the totality of circumstances and the criminal antecedents are also to be weighed. They are to be weighed in the scale of collective cry and desire. The societal concern has to be kept in view in juxtaposition of individual liberty. Regard being had to the said parameters, we are inclined to think that social concern in a case at hand deserve to be given priority overlifting the restriction on liberty of the accused. So there should be balancing act of the social concerns and liberty of the accused, but the judgment is saying. Now, Bhagwan Rama Shinde Gosai and others versus State of Gujarat 1999. In this case, the Honorable Supreme Court observed as when a convicted person is sentenced to a fixed period of sentence, and when he files an appeal under any statutory right, suspension of sentence can be considered by the appellate court liberally unless there are exceptional circumstances. Of course, if there is any statutory restriction against suspension of sentence, it is a different matter. Similarly, when the sentence is life imprisonment, the consideration for suspension of sentence could be of different approach. But if for any reason the sentence of limited duration cannot be suspended, every endeavor should be made to dispose of the appeal on merits, more so when a motion for expedited hearing of the appeal is made in such cases. Otherwise, the very valuable right of appeal would be an exercise in futility by a flux of time. When the appellate court finds that due to practical reasons such appeals cannot be disposed of expeditiously, the appellate court must bestow special concern in the matter of suspending the sentence so as to make the appeal right, meaningful, and effective. Appellate courts can also impose similar conditions when bail is granted. Now, another case, very important case of Manu Sharma, Siddharth Vasisht or Manu Sharma versus State and City of Delhi of 2000, reported in 2008, also known as Jessica Lal murder case. In this case, the Honorable Supreme Court held that we are conscious and mindful that the main matter appeal is admitted and is pending for final hearing. Observations on merits, one way or the other, therefore, are likely to prejudice one or other party to the appeal. We are hence not entering into the correctness or otherwise of the evidence on record. It, however, cannot be overlooked that, as on today, the applicant has been found guilty and convicted by a competent criminal court. Initial presumption of innocence in favor of the accused, therefore, is no more available to the applicant. Coming to another case, that is Vijay Kumar 2002. In this case, the Honorable Supreme Court observed as in considering the prayer for bail in a case involving a serious offence like murder punishable under section 302 IPC. The court should consider all the relevant factors like the nature of accusation made against the accused, the manner in which the crime is alleged to have been committed, the gravity of offence, the desirability of releasing the accused on bail after he has been convicted for committing serious offence of murder. It has also been observed in some of the cases that normal practice in such cases is not to suspend the sentence, and it is only in exceptional cases that the benefit of suspension of sentence can be granted. Now coming to another case, that is Hasmat 2004 6 SCC 175. Section 389 of the CRPC deals with suspension of execution of sentence pending the appeal and a release of the applicant on bail. There is a distinction between bail and suspension of sentence. One of the essential ingredients of Section 389 is the requirement for the appellate court to record reasons in writing for ordering suspension of execution of the sentence or order appealed. If he is in confinement, the said court can direct that he be released on bail or on his bond. The requirement of recording reason in writing clearly indicates that there had to be careful consideration of the relevant aspects, and the order directing suspension of sentence and grant of bail should not be passed as a matter of routine. Now, coming to another case, that is Atul Tripathi versus State of Uttar Pradesh and others, reported in 20149 SCC 177. It says service of copy of appeal and application for bail on the public prosecutor by the appellant will not satisfy the requirement of first proviso to section 389 1 CRPC. The appellate court may even, without hearing the public prosecutor, decline to grant bail. However, in case the appellate court is inclined to consider the release of the convict on bail, the public prosecutor shall be granted an opportunity to show cause in writing as to why the appellant be not released on bail. Such a stringent provision is introduced only to ensure that the court is apprised of all the relevant factors so that the court may consider whether it is appropriate case for release having regard to the manner in which the crime is committed, gravity of the offence, age, criminal antecedents of the convict, impact on public confidence in the justice delivery system. Now, coming to another case, that is Kishori Lal versus Rupa and others, reported in 2004 7 SCC 638. Section 389 of the CRPC deals with suspension of execution of sentence pending the appeal and a release of appellant on bail. There is distinction between bail and suspension of sentence. One of the essential ingredients of section 389 is the requirement for the appellate court to record reasons in writing for ordering suspension of execution of the sentence or order appealed against. If he is in confinement, the said court can direct that he be laid on bail or on his personal bond. The requirement of recording reason in writing clearly indicates that there had to be careful consideration of the relevant aspects, and the order directing the suspension of sentence and grant of bail should not be passed as a matter of routine. The appellate court is duty bound to objectively assess the matter and to record reasons for the conclusion that the case warrants suspension of execution of sentence and grant of bail. In the instant case, the only factor which seems to have weighed with the High Court for directing suspension of sentence and grant of bail is the absence of allegation of misuse of liberty during the earlier period when the accused respondents were on bail. The mere fact that during the trial they were granted bail and there was no allegation of misuse of liberty is really not of such significance. The effect of bail granted during the trial loses significance when, on completion of trial, the accused persons have been found guilty. The mere fact that during the period when the accused persons were on bail during trial, there was no misuse of liberties does not per se warrant suspension of execution of sentence and grant of bail. What really was necessary to be considered by the High Court is whether reasons existed to suspend the execution of sentence and thereafter grant bail. The High Court does not seem to have kept the correct principle in view. Now, coming to another judgment, that is B.J. Kumar versus Narendra and others, reported in 2002 9 SCC 364. It was held that in considering the prayer for bail in a case involving a serious offense like murder, punishable under Section 302 of the IPC, the court should consider the relevant factors like the nature of accusation made against the accused, the manner in which the crime is alleged to have been committed, the gravity of the offense, and desirability of releasing the accused on bail after they have been convicted for committing the serious offense of murder. Now, coming to another case, that is Basant Tukaram Pawar versus State of Maharashtra, that was reported in 2005 5 SCC 281, and second judgment Gomti versus Thakurdas and others, reported in 2007 11 SCC 160. The principle in this is, bearing in mind the above said principles of law, the endeavor on the part of the court should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the convict stands for fair chances of acquittal. If the answer to the above said question is to be in the affirmative, as a necessary corollary, we should have to say that if ultimately the convict appears to be entitled to have an acquittal at the hands of this court, he should not be kept behind the bars for a pretty long time till the conclusion of the appeal, which usually takes very long time for decision and disposal. However, while undertaking the exercise to ascertain whether the convict has fair chances of acquittal, what is to be looked into is something palpable. To put it in another words, something which is very apparent or gross on the face of the record, on the basis of which the court can arrive at prima facie satisfaction that the conviction may not be sustainable. The appellate court should not reappreciate the evidence at the stage of Section 389 of the CRPC and try to pick up few lacunas or loopholes here or there in the case of prosecution. Such would not be a correct approach. So, friends, that was all about Section 389. I have quoted more than 10 judgments of the Honorable Apex Court. This is all about this Section 389. I would at the end say thanks for watching and also request you to please subscribe to my channel so that I am motivated to bring more and more serious topics through this media before you all. Thank you again for watching. God bless you all.